I think we can now hear from our first speaker, Mr. Arnold Perl. Mr. Perl, if you would come forward, and Ms. Amy Batchelder will be the next speaker. Good morning, Mr. Perl.
Good morning, Madam Chairman and members of the board. I'm Arnold Perl of the law firm of Glankler Brown, appearing on behalf of the Tennessee Chamber of Commerce and Industry. The president and CEO of the Tennessee Chamber, Ms. Deborah Woolley, is here with me today. The Tennessee Chamber has a natural interest in the proposed election rules, given that Tennessee's union membership in the private sector is 2.2%, the second lowest in the United States. I've submitted to the board my presentation in advance for the purpose of allowing you to ask whatever questions that you have. Now maybe my time can start, Madam Chairman. As the board observed in Excelsior Underwear, which you cited frequently in your report, the rules governing representation elections are not fixed and immutable. They've been changed and refined, but generally always in the direction of higher standards. In our view, that regrettably is not the case here, and I'd like to explain why we feel that way. The current rules for the conduct of representation elections, in our view, do not build in unnecessary delays. Almost all elections, as your report had, take place within 56 days of the filing of the representation petitions, and the median time for the holding of elections is only 38 days. In our view, this hardly resembles unnecessary delays, since the board itself, over the years, has stressed that the opportunity for both sides, both the employer as well as the union, to reach all the employees is basic to a fair and informed election. Now, a notable exception to that is the board's current blocking charge policy, which you asked for views on. That policy has been abused over the years by unions, in our view, for their own gain, to manipulate the timing of representation elections. Some of you may remember when I served on the board's last advisory panel in the 1990s, 1994 to 1998, with the union bar as well as the management bar. The management bar, to a person, strongly urged the board to abandon its blocking charge policy. And yet, that blocking charge policy is still around today and represents the pinnacle of unfairness and unnecessary delays. Now, the proposed rules for quickie elections will prevent or impede a free and reasoned choice by the electorate, which goes against what the board has sought to do with its high standards. Now, a primary goal of the board's proposed rule amendment is to conduct elections more speedily. And this quickie election model for representation elections seriously compromises, however, the board's self-professed duty, and it is a duty, not a goal, to conduct secret ballot elections under circumstances which ensure an informed electorate. Now, Congress entrusted to the board the determination of rules, but did so to conduct elections fairly. Just consider the context under which these elections take place. Legally, unions can conduct currently an organizing effort in secrecy without any notice requirement to the employer. Once a union has gained maximum support, it files its petition, and the board, under the new rules, would schedule an election in far less than half the time provided under the current rules. And under such circumstances, there would be entirely inadequate time for employees to hear the other side from the employer on the disadvantages of union representation. The board's quickie election model also constitutes an impermissible limitation on the time given for an employer to communicate with its employees. And as stated in our presentation, we explained why and how that violates the congressional mandate and intent of Section 8C. Now, I'm going to spend just a few moments on something that the board said had a preliminary view on, and that's the rule, the policy that would be in the rules not to allow any pre-election litigation unless it amounts to affecting 20% of the unit. When you look at the case that I cited and provided you an anatomy with of all the things that happen of ITT lighting fixtures, that provides a lesson learned of how protracted litigation results when critical unit issues are not resolved by the board prior to the election. In that case, it involved the company's group leaders that amounted to at most 10%, not 20, but 10% of the unit. And the employer sought to get a determination in the pre-election hearing that the group leaders were supervisors and therefore should be excluded from the unit. The regional director, while he held a hearing, did not make a resolution of that issue and left it to the challenge ballot procedure. That case went on for 5 years, all the way to the United States Supreme Court, with the employer urging that the group leaders' open and pervasive union activity affected the fair and free choice of voters who were voting not by challenge, but voted in the election. Finally, the board, at the end, found that all the group leaders were supervisors, but by then it was too late. The United States Court of Appeals for the Second Circuit had heard that case twice and vacated finally the board's election results. So there was no winner, not the employer, not the union, not the employees. In conclusion, Your Honor, we're gratified that you've held these hearings, stated you had an open mind, wanted to learn from the experiences of others. But in our view, there is a test. The litmus test for this proceeding must be, will the quickie election model ensure an informed electorate? And we don't believe that this model passes that critical test. This board, and I was part of it at one time, has a distinguished history, and I hope that the proud legacy is retained and that there's a reconsideration after you hear the views of this distinguished group that the chairman has spoken of from all sectors, that you reconsider what is really best in the interests of employees, employers, and unions, and especially for the distinguished history and legacy of this agency.
Do my colleagues have any questions?
Mr. Perl, you spoke about the blocking charge policy, and in the notice of proposed rulemaking, we invited comments on that question and posed a range of options as to how allegations of unlawful conduct prior to elections could be handled. Do you have any views on which of those options would make sense?
Yes, I saw that you had 9 different options, Member Becker. And when we made our recommendation on behalf of the management bar and the advisory panel, I think it was 1995, you have a record of that, we urged the board to reconsider that and to basically eliminate, and that's one of the options you have in there, I think it's number 8, just eliminate the blocking charge policy. Hold the election. If there was such serious conduct that was either set aside the election under the current blocking charge, the union can file objections. You can handle this in your post-election proceedings. But to go ahead and within a week, I had a case in the state of Florida. 1 week before the election was held, the union filed charges, sought to block the election. The board blocked the election with less than a week to go. All the employees had been expecting to vote in this election. The notice of election had already been posted. And now it has to be explained, no, we won't hold an election. That just doesn't seem, not only does not seem fair, it really jeopardized, I think, the process in the end, because people who were going to vote, that vote was taken away from them. And there's been a lot of comment. You cited in your majority report, along with the dissent, the very astute article written by Bert Subrin, who worked out here and was held in such high regard. His article was in the Labor Law Journal, Blocking Charge Policy, Wisdom or Folly. It was a great article, and I read it several times when we did our work in the advisory panel on blocking charges. I think this is one area where if you want to do away with unnecessary delay, the blocking charge, to me, is the poster child for unnecessary delay.
Thank you for being with us today. Thank you for coming here from Tennessee. We appreciate your thoughts, and we'll take them into consideration.
Chairman Levin, thank you for having us.
Thank you.